I am Magdalena Morales Aina. I am currently serve as the Director of El Paso County Community Supervision and Corrections Department. And today you are at the advanced discussion track. Our first session will provide evidence-based guidance on best practices for referring clients for competency to stand trial and insanity evaluations by Dr. Marshall Smith. He's an experienced forensic psychiatrist, and he will share lessons learned from the real case studies with a focus on distinguishing between psychosis due to severe mental illness, substance-induced psychosis in the context of criminal responsibility determinations. Welcome, Dr. Smith.
Thank you. All right, well, thank you very much. I'm honored to be here, and I'm really excited to be able to talk about this particular topic with you. I am a forensic psychiatrist, and I'll tell you what that means a little bit later, because sometimes people think that when you say I'm a forensic psychiatrist, they think that that means that you do psychotherapy on dead people. That is not true. So I will tell you what a forensic psychiatrist is as we go forward. But before we get into the talk, we got to talk about something really, very, very important, and that's college football. Okay? Any UT fans? UT this weekend, not so good. What about Aggies? Any Aggies in the audience? Okay. Aggies won. Two other colleges we're going to talk about, Texas Tech and U of H. Because Texas Tech and U of H are going to come into this talk a little bit later. Right about in the middle of this talk, we're going to hear a little trivia about Texas Tech and U of H. So why are we even talking about competency to stand trial and sanity evaluations? Well, if you look at the United States Constitution, look at the Fifth Amendment. The Fifth Amendment addresses due process and also the right for people to not self-incriminate. Then you move forward, look at the Eighth Amendment. The Eighth Amendment protections for cruel and unusual punishment. You're talking about the legal process and people with mental illnesses. And then also the 14th Amendment, due process and equal protections clause. So those all deal with mental health and the law. So that tells us, it gives us the basis for why is this even important, why do we need to understand what we're doing. And really, we all work in this space, and it's up to us to be familiar with the statutes and the laws so that we maintain the integrity of the judicial process. So that's the purpose of going over this and reviewing this information that we're going to be going over. Hopefully we can have fun. This is the agenda. I'm going to tell some stories about patients that I've had in the past. Also, we're going to watch some videos, and I am going to, you heard somebody in the general session mention HIPAA. So I'm not going to violate HIPAA. I'm not going to give any personal information. Some of you, I know there's some attorneys out here, some judges, other mental health professionals, but sometimes you'll hear somebody say, well, I can't tell you about that because of HIPAA. Has anybody ever heard that before? And you get very frustrated, right? Like, I need to know this. Well, how do you even spell HIPAA? So let me tell you, how many of you think it's HIPPA? Is that HIPAA, or is it HIPAA? It's AA, okay? Not HIPPA. So if somebody tells you in an email, sorry, I can't discuss that with you because of HIPAA, and they spell it wrong, you might want to contact them and get the information that you're looking for, okay? So before we get into the actual talk, there's some things that you just have to be aware of if you're going to work in this space. And I noticed with the little bag they gave us, they actually included this. Does that look familiar to anybody? If you look in your bag, I think this is excellent because it's actually the Texas Mental Health and the Intellectual and Developmental Disabilities Law Bench Book. That is something that if you're working with competency to stand trial and sanity evaluation, you need to be familiar with this. And it's not much. It's just the competency part and the sanity part, not the whole book. But you just have to look at that, be familiar with what they're talking about because they're quoting statutes They're giving guidelines on how to do competency, how to do sanity. And if you don't know that this book exists, then you're doing yourself a disservice because a lot of information is in this book to guide you on where you need to go. If you look right to the left of that, you see where it says DSM-5 TR? Well, that is the Diagnostic and Statistical Manual for Mental Disorders. That is what we use as mental health professionals when we make diagnoses. And so you don't have to know the whole book. You just need to have the book and be able to reference it when you get a report back or when you're talking about competency to stand trial or sanity when somebody's mentioning a diagnosis to you. You need to know what that diagnosis is, and also you need to be able to look at the criteria for that diagnosis to give yourself some way of looking at a report to tell if, okay, does it make sense? Does it not make sense? And so I would recommend that you have a copy of the DSM with you and be able to reference it when you need to. A couple of other things. If you have anything to do with competency to stand trial and sanity, you have to have the Texas Code of Criminal Procedure. If you don't have that, then this is where all the, chapter 46B for competency, chapter 46C for sanity, it comes right out of this book. And it gives you all of the guidelines, it gives you everything that you need to know straight from that book. So if you don't have it and you work in this space, you're really hurting yourself because you may think that people are talking about competency or sanity and that's just the way that it is. Well, it's not just the way that it is. It's coming straight from this book. So make sure you get a copy of it. Texas Health and Safety Code, that's another thing. You don't have to know the whole book, just chapter 574. Chapter 574 deals with mental illness and when somebody can be court-ordered to mental illness treatment, a court order from a judge that says you need to have this treatment. So those are the references that you need to know about or you need to be familiar with if you're working in this area. And so as we move forward, you're going to see that I'm going to refer to these sources. But before we get into that, I'm going to show you a short video that's going to go through everything that we're going to talk about. Competency, sanity. It's going to talk about a not guilty by reason of insanity plea. But there's going to be one thing in this video that's not accurate. And see if you can pick it out, okay? Because there's a lot of misunderstanding when it comes to competency and sanity and what happens to people if they're found insane or not guilty by reason of insanity. So as we watch this, try to pick out the thing that's not accurate.
An accused cop killer pleading not guilty by reason of insanity. Joshua Lopez, who shot Elmendorf Police Chief Michael Pimentel to death nearly 4 years ago, now on his way to a mental health hospital for the criminally insane.
Paul Venema in court as the judge delivers that sentence, and the police chief's sister delivers a scathing address to Lopez.
We're going to take up 2014 CR 9680.
After years of legal wrangling and many competency hearings, Joshua Lopez enters his plea.
How would you like to plead? Guilty or not guilty?
Not guilty by reason of insanity, Your Honor.
Lopez shot and killed Elmendorf Police Chief Michael Pimentel during a traffic stop. He'd stopped Lopez to arrest him on an outstanding warrant for graffiti. Lopez was charged with capital murder. When it was learned that he had diminished mental capacity, the district attorney opted not to seek the death penalty. Several competency hearings followed until today's plea agreement was reached.
Therefore, the court, accepting the evidence in the case, will find you pursuant to the law and having no choice in that regard, not guilty by reason of insanity.
Following that sentencing, Chief Pimentel's sister addressed Lopez.
And in my eyes, you were the lowest person in my world. And I will go to my grave making sure that you stay put. There's nothing more than I want for you to live a horrible life. Horrible.
As for the length of Lopez hospital stay, indeterminate. He'll be evaluated periodically. If he's ever determined to be sane, he'll be released a free man. Paul Venema, KSAT 12 News.
So what was inaccurate in that? The ending? Okay. Somebody, who said the ending? I heard somebody. What was inaccurate about the ending? Exactly. It said when he's determined to be sane, he will be released. That's inaccurate. And if you review the information in those sources that I put up here, you will see that that's not true. But if you don't know what's in the references, you may think that. And a lot of people have a lot of misunderstandings about these topics. And so somebody will hear that on the news and say, what? He's going to be released when he say? And it's not even accurate. So good job in picking that out. So what about the whole process? Overview of this process. You can see here, I'm not going to read through all the slides, but the thing that I want to point out is when you're talking about competency to stand trial, you have to have a crime or a charge, you've been charged of a crime, that the possible penalty could be jail time. So what is that? Class A misdemeanor, Class B misdemeanor. What about Class C? No, because it doesn't come with jail time. Or it could be a felony. And then somebody raises the question of competency, an evaluation gets done, and then there's a decision that's made either competent or not. If it's not, then what happens? Well, we're going to get into that and talk about what happens with that, okay? The one thing that I would say, as I do a lot, over the last 2 years, I think I've done more than 500 of these, mainly in Bexar County and Harris County. And oftentimes, believe it or not, and I don't know if this is true, but the clients will say, I don't have no idea why I'm meeting with you. Nobody's told me anything. And I say, well, what do you think this is for? And they say, well, it's just for court. And so they don't understand why I'm talking to them, why I'm doing a competency eval. They don't understand what it means, what the possibilities are as far as the outcome. So my advice to you with putting this slide up here, if you are an attorney or you're a defense attorney and whoever's ordering this, make sure that the client understands what it is that you're asking for and why you want them to have a competency evaluation. So now that you want to have it, who's going to do it? What type of expert could it be? It could be a psychiatrist or a psychologist can do this evaluation. Now, I'm a forensic psychiatrist, meaning that I did an extra fellowship in forensics. My bias is that the more training you have in this area, the more you're into it, you've got training. So I would prefer, if you're going to have a psychiatrist do this, you want a forensically trained psychiatrist, not a general psychiatrist. Not that a general psychiatrist can't do it, but the forensic psychiatrist has more training in this area. As I mentioned, psychologists also do these evaluations. There's also a forensic psychology fellowship as well. So best practice here, I think, is to have a fellowship-trained expert to do the evaluation. I think it makes a lot of difference. Now, notice on this slide here, you've got the appointment of experts, and then there's a reference at the bottom. Same on this side. All of the slides are going to have the topic and then the reference at the bottom so that you can go to the source document later and look exactly where the language is pertaining to that slide. So I just orient you to the slide right now. I won't mention that as we continue to go forward. So, making the distinction, does the person have a mental illness or some type of intellectual disability? That's the first thing that you have to realize in order to say whether somebody is competent or not. Sometimes I'll get cases where a person has no mental illness and they have no intellectual disability, but their attorney will say, well, they're saying this and they're saying that. There may be some other reason why they're saying this or they're saying that, but they do not have a mental illness and they do not have a developmental disability. So therefore, based on the statute, they cannot be found incompetent to stand trial. Maybe they're making it up. Maybe they're malingering, and we'll get into what malingering means later. But you have to have a mental illness or intellectual disability to be found incompetent to stand trial. Another thing, there's things that we look at when we go and do an evaluation. It's not just based on how I feel or, what the person tells me. No, it's based on the statute. And the statute tells you exactly what you have to go through, exactly what you have to talk about in order to make that determination as to whether or not somebody is competent to stand trial or not. I've had several defense counsel contact me and say, hey, you know what? I'm really confused about this whole competency to stand trial. Can I sit in and watch you do it? And I'm like, sure, I don't have any problem with that. And they'll get in, their client will be there, they'll introduce the client, they'll introduce me, and they just sit there. Most of the time, you don't have time to do that because you're either in court or doing other things. But the ones that have sit in, they're like, oh my God, I learned a lot just from watching this process. And so it's based on the statute. But if you don't know the statute, then guess what it's based on? It's based on your opinion, which is not in accordance with the statute. So just understand that when we do these evaluations, it's not just we're just talking to somebody and trying to figure something out. We have to follow the statute. It's not an arbitrary thing. Now the report. You're going to get a report back from us, and in that report, we're going to say whether we think the person is competent to stand trial or not competent to stand trial. And it's very important for you to look at that report and understand what it means, what it is saying. One of the things that I have heard people say to me is, well, the person is not competent to stand trial, but you didn't continue and do the sanity evaluation. Well, guess what? You can't. If somebody is deemed, if I find somebody is not competent to stand trial, I can't then keep going and do the sanity evaluation. It's against the statute. Sometimes people don't know that, and so they ask the question, hey, well, why didn't you do the sanity evaluation? Okay? What about commitment? This case right here, I'm going to give you a case. You guys tell me if you think this is right. If you look at the top, there's an A. Can anybody see it? Can anybody read what the A says? Okay. You can see that on the side? So I'm going to give you a case. Tell me if you think this is right. So I did a case of a gentleman. I think he was 19 years old, and he had a crime that was in C at the bottom, down one of those. He was out on bail. His family paid $10,000 to get him out on bail. So he had been out for 6 months. The issue of competency never came up, but now it did. So I was asked to do a competency to stand trial evaluation, which I did, and I found that he was not competent to stand trial because he had some intellectual disability, okay? So I put the report in, sent it in. Next thing I hear, maybe 3-4 months later, he's coming up on my schedule again. And I'm like, wait a minute, I already saw this person. But after my report got put in, guess what happened to him? A warrant was put out for his arrest, and he was put in jail based on B and C. You think that's right or not? Why isn't it right? Because A says only what? Okay, this is a question that I have, because to me it didn't seem right. But as I inquired about it, what I learned was across the state, there's people in this same category that are getting warrants put out for arrest and put in jail because the explanation I got was you don't have to focus on A, you can just skip to B and C. I don't know. Maybe some of you can help me to understand that. But this is a real case that I'm talking about. So how long does somebody get committed for competency? Let's say you're found incompetent to stand trial. How long can you stay in the process of trying to be restored to competency? Well, it's right here. The statute says it. Do we follow this all the time? We should, right? So it could be up to 6 months, because depending on the type of charge that you have, your initial period is going to be 120 days or 60 days. And then you can ask for an extension. What is the criteria to ask for an extension? Likely. You think, hey, I just need 30 more days and I can get them there. I can restore them. What if you don't think you can restore them? Is it right to ask for another 30-day extension? No, not according to the statute, it's not. So then what happens if you get to that, it's been 6 months now, the person is still not competent, what do? Did you just keep them in there and keep trying to make them competent? Do people go past 6 months in competency restoration? Why is that? I just asked the question, why? Why? I've seen people in competency restoration for over a year or more. And I'm gonna take questions at the end. I'm gonna hopefully have some time for questions at the end. And so if we follow the statute, we need to follow these guidelines that tells you how much time can a person be in this process before you have to call it and move on to the next step. So what is the next step? What if somebody's not competent to stand trial? What do you do next? Civil commitment. So we're going to talk about that. But before we get into this, I'm going to show you this video. Again, this is where people, family members and others might not know the statute, so they may think that this is what's supposed to happen. And this talks about having a factual knowledge and a rational knowledge, okay?
Right now, a doctor says Aldo Alvarez, a mentally challenged man shot by a Palm Beach County Sheriff's deputy, is competent to stand trial. News Channel 5's Brian Etton is at the place where all of this began. He's in Aldo Alvarez's Royal Palm Beach neighborhood.
Aldo Alvarez could be back here with his parents in his Royal Palm Beach home, released from a mental health facility and back on house arrest at some point after what happened today in court. This after a doctor told the judge this morning that the mentally challenged man has regained competency and is now fit to stand trial after spending months at the South Florida Evaluation and Treatment Center. Alvarez was shot by a PBSO deputy in May of last year after the deputy claimed Alvarez attacked him in his driveway. Alvarez's parents say he is schizophrenic, and they question whether he can really understand the court process and whether he is actually competent.
I don't think he's competent. That would take more time than that in order for him to become competent. He need more time, I believe, as far as about really, treatment-wise. I don't think so.
Probably he learned that. I mean, who's the judge, who's the prosecutor, things like that. But after that, I don't really believe that he's ready. I don't think he's ready.
Alvarez's attorney told me he questions whether his client is really now competent or if he was just told over and over again what to believe about the court system and that he now actually only appears to understand what's going on. Remember, the state attorney did rule that deputy was justified in shooting Alvarez. Coming up next month, another court appearance where a lot of decisions about what happens next will be made. In Royal Palm Beach, Brian Enton, WPTV News Channel 5.
Okay, so again, according to the statute, you have to have a factual and rational understanding of the proceedings, and you also have to be able to assist in your own defense. So what did you hear his mother say? He was parroting what he did. Right, and he had more of the factual stuff, like, okay, I know what a judge is, I know what a prosecutor is, I know this, I know that. But what does it mean to have a rational understanding? Exactly. Internal conceptualization of how do you apply it to your case? How can you talk about it, the pros, the cons? And so that's the other piece that is necessary. So whoever did this evaluation on him must have made the opinion that he had both a factual and a rational understanding. Therefore, they found him competent to stand trial. So again, the main point that I'm trying to make on this is it's not just an arbitrary decision or based on how I feel today. It's based on this actual statute, okay? So we talked about civil commitment being the next step. When you get to civil commitment, we're talking about subchapter E and subchapter F of 46B in the Criminal Code of Criminal Procedure. I want you to focus on the last bullet here where it says subtitle C, Title 7, Health and Safety Code. Now, I know probably most of the people in the audience don't know what Title 7 says. You know, as a psychiatrist, and even as a forensic psychiatrist, I had to go look it up and see what it says. You know what? It's different for every state, but in the state of Texas, it exists, and you have to go and you have to look at it. And the thing that's really important about this is that whenever you do a civil commitment, you have to have 2 physicians that do a physician certificate. And that certificate should be based on the health and safety code. I've read physician certificates where the physician said what they thought and this and that. It had absolutely nothing to do with the code. Okay? They just put in what they thought. I saw one doctor, all he did was put a mental status evaluation in his certificate. The certificate needs to be very specific and related to the health and safety code. So this slide, I'm going to take just a minute to show you where the confusion comes in. So straight out of the health and safety code, look at the number at the top for extended inpatient and extended outpatient. What's the difference? One number, right? So you got 574.035 and 574.0355. Because it's one number different, what do you think happens sometimes? They quote the wrong statute and don't even realize that that's what they're doing, if they even use the statute. So if you see a physician certificate, make sure it's in accordance with the right statute. Because you don't want to be dealing with a patient that you're trying to determine if they need outpatient versus inpatient and you're using the wrong statute. Because look at under inpatient. What does it talk about? It talks about harm to self or others. It doesn't say that for outpatient. Outpatient says inability to live safely in the community. Totally different thing. If you drop down to like the 3rd or 4th bullet on the extended outpatient, it says actions occurring within the 2-year period immediately following or immediately preceding the hearing. So in that certificate, that physician can talk about actions that have happened over a 2-year period. Also, if you look at the last bullet, for inpatient, it says clear and convincing evidence is the standard, harm to self or others. If you look at outpatient, it still has the clear and convincing standard, but it's living safely in the community. So totally different language. One of the things that you see in the inpatient, look at the second bullet there in the red. It says they can't provide for their basic needs, including food, clothing, health, or safety. That is for an inpatient commitment. If they're able to do those things and they are an outpatient, like say in the outpatient competency restoration program, the physician certificate should not say that they cannot provide for their basic needs of food, clothing, health, or safety. And if it does, what do you think that physician did? He used the wrong statute, or she used the wrong statute. So when you get a physician certificate back, make sure you look at it, make sure you read it, make sure it makes sense, make sure the right statute is being used. This is a quote from a patient. I used to do a group. It was in a maximum security forensic hospital. I used to run a competency restoration group. This is what one of the people in the group told me or said. What do you think about this quote? You think he learned the material? No? Exactly. And you have to think about that. You have to consider that. Like, what is the person's motivation? Now, the next slide I'm going to show you, we're leaving competency, we're going insanity. The next slide that I'm going to show you is a reason for it. It's not that you guys are going to think that I need to have a competency evaluation done on myself, okay? This is meant to make you think. And maybe some of you may know who this is, and some of you may not know who this is. Does anybody recognize that? They say a picture is worth 1,000 words, right? So who is this? Little Red Riding Hood, right? And when she sees grandma, she's like, something's not right, right? I know this is my grandma, and this is her house and her bed, but something's just not, right? And she says, Grandma, what about your ears? And you guys know the rest of the story, right? Well, this is the attitude that the expert needs to have when you do a sanity evaluation. It's not like a straightforward clinical examination where the person says, I have this, and you say, okay, you have that. Sanity requires you to be suspicious. And you have to inquire about things. You have to see if it makes sense or if it doesn't make sense. You just don't take it for face value. And I've read a lot of sanity reports. I used to work as a regional consultant where I had to read all of the reports from all of the psychiatrists in that region. And oftentimes I would find that they would just take what the client said and take it at, okay, that's what they said. They said they didn't use drugs, so yes, they didn't use drugs, right? You just can't have that. You gotta have more of a forensic mindset and not a straightforward clinical mindset. So just a little bit of history, real quick. I know some of you like history, so we'll talk about this whole insanity defense. You know, McNaughton, this was in England back in the 1840s. He killed the prime minister's secretary, and he was found not guilty by reason of insanity. How do you think the Queen felt about that? The Queen was very upset. She said, no, you know what, we need to change these rules. So they actually changed the rule, and they came up with the McNaughton rule, which is, did they know right from wrong? And then we fast forward. Anybody know who this is? So John Hinckley, 1981, what did he do? He shot President Reagan. But before his case, in the United States, we had, the standard was the American Law Institute, which added a volitional component, which meant, could they resist doing the action that they did? It's called the irresistible impulse. And so for John Hinckley, he was found not guilty by reason of insanity. And guess what? How do you think Congress felt about that? Congress was very upset, so they changed the law. They said, you know what, we're going back to the McNaughton rule. Either did you know right from wrong? It doesn't matter this irresistible impulse, right from wrong, okay? So then we fast forward, where do you think John Hinckley was from? He's from Dallas. Where did he go to college? Texas Tech. I told you Texas Tech was going to come back into this, right? Texas Tech. What case is this? Andrea Yates. What did she do? She drowned her kids, right? When Andrea Yates killed her kids, the standard was right from wrong. She said she knew it was wrong. She was found guilty in her first trial, but then they had a second trial. Why do you think they had a second trial? Because in the first trial, a forensic psychiatrist got up there and said that she did what she did based on an episode of Law and Order. There was no episode of Law and Order, so when they appealed it, she got a new trial. The second trial, she was found not guilty by reason of insanity. And it made everybody upset because they said she knew what she did was wrong. But the jury found her not guilty by reason of insanity. Okay? So what is a serious mental illness? It's just this list here. So if you're not a mental health professional and that DSM-5 that I told you about, these are the diagnoses that you need to be familiar with. You don't need to know the whole book, but just be familiar with these. Differential psychosis. So somebody is psychotic. Why are they psychotic? Is it because of a mental illness? Is it because of something else? Look down at the bottom. You see that methamphetamine and the spice or synthetic marijuana? Those are very common and they can cause psychosis. So just because somebody is psychotic doesn't mean they have schizophrenia or some other mental illness. And you have to make sure that you think about these drugs. Because if they are high on something and they commit a crime, Should they be found not guilty by reason of insanity? No. So when we do sanity evaluations, we need information. We need reports. We need police videos. Everything that you see on this slide can be helpful because we're trying to put it together to see, do we think the person should be held responsible for what they did or not? These videos are so important. If you have police videos, send it to the expert. Witness statements are also very helpful. Information from family members can be very, very helpful in trying to get this right. If we don't have this information, we're at a disadvantage when we're evaluating that person to see what our opinion is going to be. So send us the information. We definitely need it. And you can see where this comes, straight out of the bench book. Everybody has a bench book because you got it in your packet when you came to the conference. So it comes straight out of that book. The three questions that we're asking: were they mentally ill at the time of the crime? It's very unlikely that they had no mental illness their whole life, and now they're in their 30s and they commit a crime. It's very unlikely that that crime was because of mental illness that they never had. Do you think people will say they had a mental illness when they get arrested, when they never have? Well, they do, and I'll give you an example of that in a second. And then, is there a relationship between the illness and what they did? Cognition of the legal right is something that's very important. Look at the second bullet on this slide. It says, if the person knows that society considers this wrong, then in the state of Texas, it's wrong. Okay? Each state has their own statute, but in Texas, that's what it says. And this is the part that caused a lot of people to be upset with the Andrea Yates case. Because she said she knew it was wrong, but she said she had to protect her kids because the way she raised her kids, they were evil. And she didn't want them to have to be living being evil. So even though she knew it was wrong, she waited for her husband to leave to go to work because she said he would have stopped her from doing it, and then she drowned her kids. So did she know it was right or wrong? Some people say yes. Did the jury get it right? Well, I mean, I wasn't on the jury, so I can't say. So hypothesis 1, do they have a mental illness? Hypothesis 2, was the mental illness severe enough that they didn't know right from wrong? Hypothesis 3, there's no mental illness. 4, drugs are involved. And 5, just motivation, they just wanted to do it for revenge or whatever reason. What about malingering? What does that mean? Basically, malingering means they're faking it because they don't want to get in trouble. Or they're trying to get some money. Or in the military, as you see there at the bottom, they don't want to go to war or some other thing, so they fake it. So malingering does exist. And in the DSM-5, it tells us to look out for malingering. Especially in a forensic setting, you have to consider malingering. The report on insanity. Look at the third bullet at the top. You see where it says analysis? That's what you should be looking for in the report. You're not just looking for history and this and that. You want whoever did that sanity evaluation to analyze everything and come up with their opinion based on a detailed analysis. The person said this, but that's very unlikely. And the reason why that's unlikely is because of this, this, and this. What's more likely is this, because if you had this, you would see this. That's what you need to be looking for in the report. Not the person said that, they didn't mean to do it, so that means they didn't mean to do it. That is not an analysis. So if you get a report like that, you may want to ask the mental health expert who did it to give more of an analysis of what is more likely, what's less likely. Why this sounds more like this happened versus this, because if it was this, you would have expected this. And because you didn't have any of that, it's less likely that what they're saying. See, that's the analysis that you need to be looking for in this report. because you're trying to make decisions based off of the report that you get back from the expert. If two experts say, you know what, the person is insane, not responsible, then you may be more inclined to go with that. But is it accurate? It may be, it may not be. But just look for the analysis. This is a big issue right here. A person is suspected of maybe using spice, but you do a random urinalysis and it's negative. Does that mean they're not using spice? No, because guess what? The random urinalysis doesn't even test for spice. If you want to test for spice with a synthetic marijuana, you have to ask for it specifically. It's not in a random drug screen. I do some inpatient psychiatry right now, and I go to the emergency room to evaluate patients all the time, almost every day. I had a guy, he came in, and he was suicidal. We did a drug test on him, and it came back negative for marijuana. He was very upset. You know why he was upset? Because he told me he smokes weed every day. So how could my drug test be negative for weed? Like, he was almost offended. He actually called his wife and said, tell him, baby. They're saying my test was negative for weed. How can that be? So if you have a case, a forensic case, and you're trying to determine whether the person was using drugs or not, don't rely on a random urine drug test. A hair follicle test is more sensitive, it costs more, and it takes more time to get back, but it can be more accurate. And that's what we're all trying to do, right? Be accurate. So what happens if a person is found not guilty by reason of insanity? They could either be inpatient, as you see at the top, outpatient, they could get civil commitment, or they could be discharged and released with nothing, depending on the case. I'm going to show you another really short video, and on this one, listen and see if you can pick out anything that's not accurate.
New information tonight in the trial of a woman who fatally decapitated a man inside his Green Bay home. After Taylor Shaw Business was found guilty on all 3 charges yesterday, a jury has now rejected her insanity plea. Police officers and detectives testified they hadn't seen any signs the 25-year-old was under the influence of drugs at the time of her arrest. Officials also noted Shaw Business had numerous competency evaluations during that judicial process and was determined competent to go forward. She's now set to be sentenced on September 26th.
Okay, what was inaccurate? Exactly. It can't be based on intoxication, because if she's voluntarily intoxicated, it's not a defense. So again, another miss. Now, if you're watching this on the news and you hear this, you may think, oh, okay, if she was on drugs, then she would have been found not guilty, but it's not the case. What about advanced discharge? Anybody know what that means, advanced discharge? So somebody's found not guilty by reason of insanity, and then they're in the hospital, and now they're going to be released from court-ordered treatment. That's advanced discharge. We'll talk a little bit about that. Last few slides, these are some of my patients, okay? So I had a patient, he had schizophrenia, he killed his mom. You can read on the slide. He didn't kill his mom because of the schizophrenia. He killed his mom because he was mad at his mom, because his mom told him that his girlfriend, who was a prostitute, was stealing his money. And so he killed her. This is probably my saddest case. He had major depression, severe with psychosis. It had been going on for several weeks. His 2 teenage boys came home from college for the weekend. He went in their room and murdered both of them. He was found not guilty by reason of insanity, but when he came back to realize what he did, you think he was trying to get off on the NGRI? No, he wanted to die. What about this one? Nope, man with no mental illness found NGRI. This was a real case. I saw him when he got out of the hospital, and he told me, Dr. Smith, I don't have mental illness. He said, I faked it. He said, when I went to jail, they told me how to do it. I had never been to jail before. I was scared. They were telling me I was going to get 6 years. So I faked it, and I was found not guilty, and I went to the mental hospital. Now I'm in an outpatient program. I don't have a mental illness. So what do I do? Say, well, sorry, got into your eye, so I'm going to keep you in it? Or do I say he doesn't have a mental illness? What do you think the right thing to do is? Doesn't have a mental illness. And guess what happened in his case? The judge discharged him. The judge discharged him. Here, Spice. The urine drug screen was negative. So guess what was said? He wasn't high on Spice. And then this person was drunk, had an alcoholic memory lapse, blackout, right? Alcoholic blackout. Does that mean he's not competent? Because he can't remember what happened? No. He was driving and he was drunk and needs to be held responsible. The last slide I had is this one video. This is just to look into the future in Texas. We don't have this in Texas right now.
Accused Winchester murderer Jeffrey Yao is due in court tomorrow for a status hearing. He's expected to plead not guilty by reason of insanity to the February killing of 22-year-old Deanne Kenny Stryker, a medical student. Police say Yao stabbed Stryker 20 times while she was studying in the town's library. Yao's lawyers will not argue he did not commit the crime. Instead, they're expected to contend that Yao is mentally ill and shouldn't be considered legally responsible for his actions, a defense that is notoriously hard to get juries to buy. These verdicts are sought in just 1% of cases. Most violent crimes, of course, are not committed by those with mental illness, and the vast majority of mentally ill people do not commit violent crimes. But when suspects do plead not guilty by reason of insanity, a 1991 study found that nearly 75% of them, that's 3 in 4, not surprisingly fail. It's because no jury, after the mindless taking of such a promising life, wants to say the words not guilty, and they shouldn't have to. But it's the only option if a jury concludes the defendant was unable to appreciate the wrongfulness of his or her crime in this state. Some other states, however, allow for another plea, guilty but mentally ill or insane, which still holds the attacker responsible for the crime. That's the key, and often results in a similar sentence, but also allows for the provision of psychological treatment. In Yao's case, his history of mental illness and violence is clear. Since 2012, he's had dozens of interactions with Winchester police, who escorted him to the hospital at least 5 times after raising alarm in his neighborhood.
He threw a planted pot against the door, and the police come up and arrested him.
And after Yao tried to break into his neighbor's home last fall, a local hospital filed paperwork with Woburn District Court to admit him for, quote, management of his condition. It's clear Yao needs treatment, and he should get it, but that in no way should diminish the seriousness of what he did. When considering under current law whether a suspect is not guilty by reason of insanity, Massachusetts jurors are forced to decide between giving a mentally ill person the treatment they need or holding a killer responsible for his or her actions. That's an unacceptable choice. A verdict of guilty but insane would allow them to do both.
So what do you guys think? You think we should have that in Texas? I don't know. Some of you are lawmakers. Maybe things can change. In the opening session, the judge talked about change. This may be one of the areas that we need to look at, or maybe not. Maybe we just stay with our current system. This was just a slide of a patient that got an advanced discharge, went through the whole process and got an advanced discharge. So it does happen. And with that, what are your questions? Any questions? Yes.
So, can you discuss the tension of, let's say I hypothetically have a defendant that is so competent as far as understanding the procedures that he can say, okay, this is not the competency hearing, this is just determine whether you're going to order a competency evaluation under the different statute. That's right, okay? But then they go to the next point and they meet with the psychologist, and they are adamant that what they're accused of, they have the legal right to do. And it's not factually correct, but that's their belief. So they know the process, they know the procedure. What is that tension between that? Because they're saying they can't help their counsel because they can't admit that what they did was wrong because they're saying they can't. Does that make sense?
It makes sense, and the answer to that is, do they have a mental illness or not? Or do they have an intellectual disability or not? If they don't, then most likely they're just telling their counsel that. Okay, and so you go back and you look in history, what type of history does this person have? If they went, let's say they weren't in special education classes, they graduated high school, they went to college, everything was great, you can rule out intellectual disability. So the fact that they're saying that to the defense counsel, it's not because of an intellectual disability. So now what about mental illness? Any history of mental illness ever? And if the answer to that is no, then most likely that's something that they're saying, and they may be malingering or some other issue, but it's not related to a mental illness or an intellectual disability. So therefore, according to the statute, it's not an incompetence to stand trial. So then you have to ask yourself, well, what is their motivation? And sometimes you may figure that out, sometimes you may not figure that out. Any other questions? Yes.
So the jury doesn't get an instruction as to what happens after an NGRI. So I think jurors think this person just walks out the door. Do you think that language was changed and jurors could know what was going to happen, that they would be more accepting of these NGRIs in trial and open-minded to finding someone not guilty by reason of insanity? It's rare.
Yeah, I think that the jury's decision, I think, should not be based on knowing what's going to happen next. But in reality, that might make somebody not want to do NGRI or make them want to do it. And so I'm not sure how educated jurors may be on that particular topic. But I think the more information and knowledge that they have, they're better able to make a better decision.
Under current law, you cannot tell the consequences of an NGRI finding. It's always proposed every session to allow for that to be shared with the jurors, and it's always defeated.
Okay, any questions on this side? Yes.
But it's often done.
I read competency and sanity evaluations daily, and I read your competency and sanity evaluations often. So can you share with this audience why you add quotes from the individual?
Yeah, so when I do my sanity reports and competency, I put direct verbatim comments from the person that I'm talking to, because I think it helps you to understand how they're thinking. If I just say, understands the charges, how do you know what the person even said? So I asked them, what are your charges? And what they tell me, I put it in quote, like this is exactly what they said. I asked them, what's the role of a prosecutor? What they tell me, I type it exactly the way they said it. Instead of just saying they understand what a prosecutor is. When the plea options, instead of saying they understand the plea options, I ask them each one, and then I verbatim comment what they tell me. Because now when you read the report, you get to get into their head and see what they're thinking. Instead of saying they understand what a plea bargain is, I may ask the person about the plea bargain. They may tell me, oh yeah, I know what that is. I took one in my last case. They offered me this, and so I typed that verbatim out. I had a case before, it was an assault case. They offered me 5 years, I could have got 15. I took the plea bargain, but I had to plead guilty to get it. I served. That helps you to really understand more about what that person is thinking, more so than me just saying they understand what a plea bargain is. So that's why I do that.
And to follow up with that, because you put that in your reports, do you find it easier to testify in court to a jury?
Yes, because I can say exactly what the person said to me. And the jury can appreciate that and understand that. So I think it's helpful for the attorney. The clients that I'm interviewing, they appreciate it too, because I tell them I'm going to put this in your own words as much as possible. And most of them appreciate that, especially the ones that are competent. The ones that are not competent, they don't maybe understand what I'm saying. But I think it's helpful for everybody. It's time. Okay, thank you very much. You've been a great audience.